Hi everyone, my name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. I feel like I haven't said that in a long time, so it's worthwhile to say. That's really our mission, right? We're a bunch of creative, passionate people that likes to solve problems and creative problems that's linked with immigration specifically. So on today's video, on YouTube and on TikTok, we are going to be talking about one of the biggest news this week. It's the public charge rule that's forever going to change the immigration landscape. And so we're going to do a deep dive into this specific news topic and give a lot of advice on what you can do if you're at that borderline, whether your green card could get approved or denied based on this new public charge rule, right? So we're going to be talking about that. Then we're going to do a success story on an E2 visa. It's a treaty trader visa from Switzerland, and it's a consulting firm, right? So it's a guy invested in the US, wants to come here to consult on graphic design. Case got approved, and it's actually really hard for consulting AI-related graphic design stuff. But we're going to show you exactly what we did, how we went about doing it. And of course, as always, if you guys have any questions about immigration, feel free to ask. Galen's right here with me, and he's going to be taking down your questions, asking, and I'll be responding for it. But before we kind of dive into the success story and the news, just wanted to share good news. Last week, if you remember, Gabby and I were sitting here and we were talking about a client that went into an interview that morning and was grilled by ICE agents and the USCIS officer about her entry because they claimed that for sure she was caught at the border. And again, if you're caught at the border and you're coming back in, and you're applying for a green card, you may have to do a waiver. And in some cases, you might not qualify for a waiver. The client was adamant that she was not caught at the border. There was no record of that, and that she is innocent. And we totally believe her, and our attorney was freaking out, but totally believe her. Yesterday, the case got approved. So within 1 week of this intense grilling, and we even had another USCIS officer on our live last week saying, hey, we're watching. Well, and I was asking, is this a tactic issue, right? Are people just actively questioning and challenging? Even if USCIS didn't know for a fact, we didn't get the answer to that. But in either case, we know last week they were adamant that our client was caught at the border. They had proof of it. They wanted the client to confess and write a statement. Our client said, no, that was not true. That is not her. And a week later, the case got approved. So just wanted to share that. And now we want to get officially into the public charge rule. Okay, ready? All right, let's do this. The newest public charge rule just dropped this week. Let me see if we have the date specifically. Nope, I don't have the date. Okay, well, it's July. So July 2026, the public charge rule is an expansion on the memo that came out last year. When the memo came out last year, we did an in-depth video talking about it. We analyzed it comparing to the two prior public charge rules, the Biden era and the first Trump era, and we went in detail. We're not going to do that today. We're just directly going to talk about what is this new rule and how does that impact people who are in the process right now and everybody who's coming afterwards. So to make it clear, what is public charge? It is a reason for denial. The government can deny people's green card if there is a heightened certainty or probability that this individual who's applying for a green card might become a public charge, might become indebted, might become a leech on society, according to some USCIS officers. Basically, they might be draining taxpayer money. So what is and how do you decide public charge? This new memo, the main thing it does is it blows out of the water all the confines and the restrictions in the prior administration. The prior firm rule was that you can consider these benefits, but you can't consider other benefits. You can only consider benefits that you've taken, but not what your family has taken. There's all these red lines surrounding when somebody will become a public charge. Only consider these narrow set of factors. This new memo blows that out of the water and says an officer can look at everything and anything. It is case specific. They will use their best judgment to decide if the individual in front of them is going to be a public charge or not. So basically blowing up all red line kind of criteria. So you might be saying, well, what are the things that they're supposed to consider? So now the officers, they have a list of factors that they want to look into. And a lot of them are pretty common sense, but let's go through some of them, right? Your prior work history, your tax returns, how much is your bank account, how much do you earn, how much does your sponsor earn, do you have any great investments, what is your education level, how likely are you able to get a new job, a higher paying job, how long have you held your job, have you used any benefits before, how healthy are you? If you are sickly, then there's a chance that even if you do get a job, you might not be able to hold the job, and you might have to drain the taxpayer money by going to the hospital, right? So these are all the things, the factors that they're looking into, and so much more. So that's the kind of parameter that this administration is doing. In the prior memo last year, they laid it out very clearly why they want to reverse the prior administration's decision, and they did so this week with the public charge rule that's final and going to be effective starting September 2026. It's a huge deal because prior to this, let's say the past 10, 20, 30 years, the number of cases in the United States and abroad of people applying for green cards and then being denied due to public charge is in single double digits. It's very, very low. It's, in the prior administration, in this administration's words, is ridiculously low. They think there are so many people who are applying for green cards and getting green cards and then becoming a debt to society. And yes, you're right that there's a sponsor, so the government can go after the sponsor to try to get the money back. But realistically, that hasn't been something that people have done, the government has done. And you can see kind of why, right? Because if the government goes after the sponsor, like, hey, you signed for this person to come to the United States, now this person might say, well, I didn't sign that, it was forged, now there's a litigation, now you have to kind of prove it, you have to waste all this money to try to get back a couple hundred or a couple $1,000s. There's other higher priorities. So the safety mechanism of making sure people do come to the US with a sponsorship isn't actually a workable system where that the government necessarily wants to enforce. And even if they do enforce it, it kind of harms everybody, right? Now the US citizen who sponsored the foreigner, now they have to pay the government all this money, and now they don't have the spending power to stimulate the economy, right? So it's a lose-lose-lose situation. The only winner is the green card holder from overseas that got the green card, and they were able to use all these taxpayer money to fund their lifestyle. So that is why they want to combat. They think that in the past 10, 20, 30 years, there's so many people who have used these public benefits. So now they want to heighten the public charge denial rate. It might be increased by tenfold. It might be increased by 100-fold. We don't know exactly how many cases are going to be denied. Obviously, that's conjecture and future planning. But they do put a number as to how much money the government will potentially save in the transfer costs, and the staggering amount of $13 billion. Just to put that in perspective, $13 billion annually, not like in the lifetime of this rule. It's every year the government thinks they don't have to spend $13 billion on people who are getting green cards from using the benefits, and from the people who will be so afraid that they won't even apply for these benefits, and so the government will save that money. $13 billion. The entire national, the entire FBI department uses less than $13 billion, right? So the entire FBI of the United States is less than $13 billion that the government thinks that they could potentially save. That's crazy. Wildlife, forestry stuff, national parks, that's like $3-4 billion a year. So $13 billion is a staggering number. There's really little credibility for that on both sides. It's so hard to estimate this. So that's just a random number that people are throwing out, that's actually in the rule and the policy. But even if half of that is accurate. Still, 6 to 7 billion is still a lot of money for the government, right? But they think they will save that money. Now, what's really interesting about this rule is that it's over 100 pages in detail responding to all the public comments. People who are for it, people who are against it. And there's a lot of recognition that, yes, we understand this will harm a lot of businesses. Why? Because that 13 billion that the government is gonna save doesn't mean it's going straight to the pocket of all the foreigners. It's a lot of businesses who are providing services to these individuals and they're billing the government, right? So now hospitals, nonprofits, a lot of different places that relied on government funds. Well, if public charge is a rule, people stop applying, people start going, well then now they have to either change their business model or do something, or else their organization will have a really big hit because the government is no longer sponsoring it. That might be a good thing, right? But it saves taxpayer money. But that is the public charge rule. Now, I feel like the public policy argument for this rule is quite strong. When I looked into this in the past 10, 20, 30 years, I was shocked by the number of cases that got denied. There's just a limited amount of cases that got denied by the public charge. And when you read through the congressional intent, there was no definition about public charge. So it is up to the whim of whichever agency head is running the organization, right? And so now with Trump in office, with USCIS, with the consulate, they are cracking down on the public charge. Well, that's why there's so much of the 75 country ban. What is concerning, though, is that even if this is right on the public policy standpoint, what is devastatingly scary is the lack of safeguards and the lack of clarity, because the emphasis is on individual officers' discretion. So if somebody only graduated high school and they have a small criminal record, they're a hard worker, but maybe the officer thinks, well, I think you're unhealthy and I don't think you have a high education and you haven't held a job for a long time, your tax return doesn't look good, I think I'm going to deny your case, even though you waited 10 plus years. Or maybe even your whole family wants to support you and in every respect you're good, but based on this public charge rule, I don't think you're going to make enough money, so I'm going to deny you. These borderline cases are going to happen, right? If this becomes rule, and it is going to become rule in September, how different officers adjudicate these cases will impact the next few generations. Now, if somebody was a homeless individual and if somebody really couldn't support themselves and they can't get any sponsors, that would have been denied in the previous administration anyways, right? But it's just saying that these cases have gotten a lot more difficult because of this memo. And so now when people prepare their green card applications, there's a lot more to prepare for. And so this is how I'm advising a lot of our clients. Whatever the old rule was, just try to double or triple it, right? So for example, in the past, if you have your sponsor is strong enough, if the petitioner has enough funds, with just the paycheck alone, that's good enough. But nowadays, that might not be good enough, especially if there's other baggage in the case. Like for example, there's prior bankruptcy, or let's say there's a lack of job history for the beneficiary, right? And so you might look at that and like, okay, well, what if the petitioner already can't work after several years? Maybe they can't make it, right? So even if paycheck alone is sufficient, now let's also use assets, right? Show your house, your stocks, your Bitcoin, your trading cards, anything that you have that is of value to get that, graded, right? So my friends and family who have a lot of gold bars, well, use that, get it graded to show exactly how much gold you have. If you have a lot of Pokemon and Magic the Gathering cards that are worth a lot of money, get those graded and demonstrate this is liquid asset that I could sell on the market and it's equivalent this much, and I have enough assets to make sure my spouse, my children, my parents are not going to be, in a place of destitution, right? So there's that. Now, assuming the petitioner doesn't have enough income or assets, then your joint sponsor have enough income or assets. And even if you do have two, but if you're sponsoring multiple people, your parents and your spouse, right? And their children, your stepchildren, then suddenly you need a lot more than try to do other things as well. Now I'm going to go into a lot of examples. So let's talk a little bit about how can you persuade an officer that you're not a public charge. And I'm not going to do the basic ones, right? I'm not going to say like, oh, look, I make enough money. Well, then that problem wouldn't have come up in the first place. So how can you prove you are not a public charge, that you are going to be able to be a productive citizen in the US and you have enough funding and you won't, become destitute and that you deserve a green card, right? How do you go about doing that? I'm trying to give you guys as much examples as I can possibly give. You can say, well, the company that I co-founded just got acquired. And here's a contract. And here's another company that acquired it, and I'm just able to sell my shares. There's this liquidation event that happened, right? Or you might be able to say, my grandpa just passed away, and I just inherited this money, right? Or I'm just named as the beneficiary of a particular trust or will from a family member, and this is what I have now, right? My socioeconomic status changed overnight. I'm not going to be destitute anymore, right? I'm borrowing from the idea of winning the lottery, but like the liquidation event. But let's say you didn't liquidate your company, you didn't sell all your shares. What if you just got an investor? You just went through Series A, Series B, right? This thing that you worked on for so long finally took off. The YouTube channel that you started years ago, finally, now Google is paying you monthly, and now you have this additional passive income, and that just happened because some of your videos have gone viral. Well, that's a new income stream, right? So show the hard work, the investments, the Beanie Babies that you collected. Finally, now on eBay, somebody bid it, and it's at a staggering amount, right? So show these things in your life that have monetary value. In the work environment, customer just left a really good review for you on Yelp, on Google, and your supervisor loved it and gave you a promotion, put your plaque up, you're the MVP at the company, and you got a promotion. Before you were barely making enough, now suddenly you're getting more, right? Or a nonprofit that you're volunteering at, now they're gonna give you a love stipend to cover a lot of your expenses because of all the contributions you have done at this nonprofit organization. Or let's say you won an award, or you just patented your design, right? You created a Lego concept, and now Lego wants to award you with something, right? Anything of that nature, media publications, awards, ceremonial events, you got recognized by the mayor, by the senator for some major contribution, and that has direct impact on your finances in some way, shape, or form, right? Your big expense just got obliterated, right? In a sense, in a good way, right? Maybe your children are now graduated and gone off to college, and they got a scholarship, and you don't have to pay for them anymore, and they're working. And so before, expenses were tight, you made it work all these years. Now you don't have to anymore because now you have so much more discretionary income, right? All of these are examples in which you can talk to the officer to show you are not going to be destitute. You are not going to be a public charge. You've survived in the United States or abroad for so long with so little and able to accomplish so much. And now this event happened and made you in a better place. And there's infinite amount of ways to kind of argue that, especially with this new rule where they're supposed to look at everything, right? So the intent of the final rule is to give the officer a lot more authority to deny everyone based on anything that they can find. Well, reverse that. Since they are supposed to look at everything, they cannot ignore anything. I'm going to say that again. Since they are supposed to look at everything to make a decision for or against your case, they are not allowed to ignore anything that you present that is of value, that is on record. So when you go to these interviews, when you prepare your case, if you're on the borderline of the public charge rule, do anything to prove your case. Your sponsors, your joint sponsors, the beneficiary, you, everything holistically to show you will not be taking benefits from the government. You will be a plus contributor, positive effect on the community. I could go on and give like 100 more examples, but I think everybody gets the point, right? Your expenses have decreased, your future earning have increased, your value has gone up. Okay, so that's what I want to share about public charge. I guarantee the denial rates for public charge is going to go up in the United States as well as abroad. We've already seen a lot of National Visa Center denials from different people, and then now they're transferring the case, and we're already redoing a lot of these cases. We've always done it, but now I'm going to see this happen more and more. So I'm recommending practitioners to familiarize themselves with a lot more finance stuff, right? Learn about how investments work, and so CD and stock portfolios and bond portfolios and gold and subprime markets, being able to master that so that when clients are in a situation, you're able to help their case get approved.
Yeah, some questions from Yogesh. The N600 case you managed to get approved, were the children at age out risk?
No, they were not age out risk. They were under, I want to say they were under 10, so they were pretty safe. But with that being said, the N600K case that we did in about 2 weeks, they can't come to the US very often. It's really difficult to be able to get the whole family here, to get all the documents, to go into the interview. It's just really hard. And so multiple stars have to align in order for them to make the trip, and they are only here for a short window. And so that's why it's difficult, because if they don't do it now, it might be, who knows, half a decade later before they can try it again, So it's not an age out risk, it's more so logistics, being able to come to the interview risk.
So yeah, feel free to add any more questions. If you sue USCIS and win, do they pay the legal fees?
I have not personally seen them do that. I have not seen my colleagues actually get a check from USCIS for things like mandamus or the APA, or let's say they take too long on the premium processing. But those are all reasons to ask them to pay for the attorney fees and for the client's fees, especially the premium processing, right? You pay additional $2,500 to expedite your case, but then your case still takes 3, 4, 5 weeks. They're supposed to refund that, right? So we haven't seen people successfully get money, but technically it's possible. But yeah, just it's not something that I see often.
What about if you lose, do you need to pay USCIS's fees?
I also haven't seen that either.
I'm transferring my SEVIS for PhD without getting full graduate audit. Will that be a problem?
I don't know. I haven't seen that as a problem just yet. Transferring SEVIS from one school to another school, it's up to both schools, the DSO. They just click the button and it transfers over and the other person accepts it, right? So whether or not whether or not you got audited and that impacts your ability to transfer and the DSO is going to hold it or not, I think that's within each school's requirement.
Yeah, they say they have defended their thesis, just the audit hasn't been done.
So unless the DSO is under strict orders saying it has to be done before we can transfer, which I don't think so, right? I think a DSO says if you want to transfer, they just transfer it, and then another school accepts it, they accept it.
How many times have you sued the federal government, and is it usually successful?
I believe we have sued the government on mandamus and APA in the past 5 years. Well, I don't know if you're going to count joint filings, right? So most of the time when we sue the government, we try to do it in a similar class action because it makes everybody's case stronger, because it shows everybody's doing it together. It's not just an individual one-off thing. There's a pattern of offense by the government, so we want to sue them all together. So usually when we do mandamus actions, we try to get at least 3, 4 people. In the past 2 years, the mandamus action, usually it's like 7 to 15 people joined together. So, if you count all of that, then 30 cases, mandamus, APA.
Do you think it's usually successful?
They all have been successful. Now, with that being said, this year, the mandamus actions we've done, we got a lot of pushback. So I think this year, Grace's team did at least 2 or 3 different mandamus actions, and each team, each lawsuit had like 3 or 4 different people. There was a lot more pushback because the trial attorney hired by the government, they are now transferred from USCIS. So in the past, the trial attorney for these type of cases, they don't usually deal with immigration. So they get the case like, what is this? They send it to USCIS, they get this resolved, right? Like, why haven't you adjudicated case that's supposed to take 10 minutes and it's taken 2 years. And USCIS usually just has one of the caseworkers immediately process it, issue a request for evidence or approve the case, and the case is done. So in the past, when we do mandamus and APA actions, usually within 1 month to 3 months, there's a closure. And it's usually approval, right? Some is a request for evidence and then an approval, but that's been the general trend. Now, there's a lot of pushback saying, you filed this mandamus too soon. Why didn't you use the other mechanisms to try to push for the case? USCIS is just overworked with all these other things, so you need to wait longer, right? So there's a lot of back and forth. But at least up to now, we haven't gotten a mandamus case denied yet, right? It's all still been successful with positive outcomes.
As a Chinese about to do the immigrant visa interview in mainland China, given this current situation, do you think I should hire a U.S. immigration attorney for this interview?
If you are in China, you cannot have representation at the consulate. So hiring a U.S. attorney, the only benefit is just for the practice, right? So you prepare your case well, you know what to bring, and you can do a couple mock interviews, and that, I think, is invaluable. You can hire that service with or without representation, right? So they don't have to be the attorney on record for your case. They cannot be there physically anyways. But letting them review your application, treat you like an intern, give you feedback, practice with you multiple times. And you can hire multiple law offices to practice with you just to see different people's perspectives, right? You can even hire prior consulate officers who worked at that embassy and that consulate and have them practice with you and train you, right? So there's a lot of that. I think that is where the value is at. The value is not in having representation on paper with a name. At least I don't think so.
If you request an InfoPass appointment and they said they may call or email you back, what does this mean may happen in real life?
In the past couple months, I want to say the success rate of the officers actually calling back is probably less than a third. So we make 3 InfoPass calls, maybe 1 will actually call back within 3 to 7 days. It's insane. Imagine calling Bank of America or, like your credit card company, and they say, oh, we'll call you back in 3 to 7 days in the middle of the night. It's crazy.
How long could it take to withdraw a motion to reopen that's currently in process?
I mean, if you FedEx it out, they get it within 2 days, and then sometimes they process it within a week.
Okay, so yeah, feel free to ask more questions. I do want to get into the public charge. One interesting comment, I think, is this is on our video from going from H-1B to tourist back to
Yes.
H-1B. Someone said it seems like this is like a method to scam the immigration system. What do you think about that?
It seems to be a way to scam the immigration system. I think maybe they're not referring to that video, but maybe they're thinking like a tourist visa and then changing to H-1B and not having to pay the 100,000 fee at the consulate. Then you're somewhat scamming because you don't have to pay the 100,000, right? But if you're merely saying you're going from one status and you change to a different status, that's somehow scheming or that's somehow scamming. I don't think that's quite right in the sense that you're paying for this, right? The government, in all of its wisdom, created a form, the 539 form. You're paying hundreds of dollars, and if you expedite it, you're paying thousands of dollars just so you can have your B1 H-1B changed to a B2 tourist, and then you have to pay another couple $1,000s to change it back to H-1B. Like imagine you call Geek Squad because your computer, had a glitch, and they come and turn it back on for you, and now they're going to charge you a couple $1,000s. Did you scam Geek Squad, right? Or did you pay them, or did they scam you? I mean, I would argue the government scammed you to go from H-1B to B1, B2 to H-1B all within a few months, and to pay like almost $10,000, right? Now, with that being said, it is still extremely difficult to do, right? It's extremely difficult to go from H1B to B1, B2, back to H1B. That's why it's a worthy success story video that we did, and we talked about all the reasons. But it still cost a lot of money, and it finally got approved, and so we're very happy about that. Yeah.
Yeah, no, I think that's interesting. Our out July 26, 2024 to January 23rd, 2025, so about 7 months, was paying rent while outside. Am I good for citizenship?
Okay. This is a question. So they are a green card holder. They've been out of the country for 7 months, and but they've been paying rent. Are they okay to apply for citizenship? Is that the question?
Yeah.
So the officer will look at the fact that you've been out for over 6 months, and they will likely challenge you on that. And they will challenge you saying you have abandoned your residency, you don't fulfill the physical presence test, and they might make you wait additional 4 years or more before applying from the day you re-enter the U.S. So, that 6 month period is very key. Now, is there a way to persuade the government and persuade USCIS to say, no, I did not abandon my residency. Look, I lived here. I paid all this rent. But that alone might not be sufficient, right? So you want to provide a lot more. It's definitely possible. We made plenty of videos on how to do this, right? If you've stayed outside of the country as a green card holder for over 6 months, but still want your citizenship, what are all the things you can do? What does a request for evidence look like? What does a NOI look like? How do you overcome it? We did success stories after success stories talking about this, but you really want to prove that the U.S. is your home, not only the fact that you paid rent, but everything else. And also, why were you gone for 6 months? Well, and then you came up with a temporary urgent reason why you needed to stay abroad.
With the with the current visa bulletin, would you recommend someone who is yet to file I-140 to file concurrently? And what do you think about general approval rates for EB1 and 2 and RFE rates?
EB2 has gotten a lot stricter in the past 2 years. EB1 stayed about the same. I wouldn't say there was like a huge change. In my experience, if you can file concurrently and you have a strong case, do it. But if you have a really weak case, then I wouldn't do it because you're wasting all the 45 application fees. What other part of that? EB1 is the extraordinary ability, right? And then EB2 and IW is national interest waiver. So somebody saying, I am so extraordinary, here's my resume, here's what I plan on doing in the United States, this is how I plan to make the United States great, please give me a green card, right? And so if you have a good enough application, you file it, you get it. And we're gonna do a EB1. We have so many EB1 success stories that we haven't done yet. But yeah, there's some good ones.
And what do you think general RFE rates are?
I believe the last time I looked into both of them, the general statistic is like 30, 40%. I take that with a grain of salt. Some request for evidence is super simple. Some is like super brutal. Just do your best. I wouldn't gamble with their RFE in the sense of like, I hope I don't get it. Like if you get it, you get it, and you do a good job, you respond to it, and you win it. I would always expect it, but if you don't get it, then cheers. It's not the worst thing to get a request for evidence. The government might be too busy. You might have to redo and package your application to be better. Yeah.
Does I-129B have to be filed in the same office as the original petition? Or is there a process to pick a different field office to consider a motion to reopen?
Say that question again?
Does I-290B...
Oh, okay. 290B.
Sorry, I probably read it.
Yeah.
Have to be filed in the same office as original petition, or can you switch it up?
I don't know. Yeah. I don't know. The only thing I know is you can only just try. Maybe they're willing to transfer it.
What's happening with the Haitians in Springfield, Ohio?
I believe their TPS, their temporary visa, is no longer extended basically indefinitely. A lot of them have to leave once it expires. A lot of them have been on TPS for decades. There's a lot of lawsuits on it, but I think the judgment is final. So if they have a way to change their status to another status, they're permitted to do that. If they can get a green card and do adjustment of status, because a lot of them came, gave birth, their children are U.S. citizens, and if they become 21, the children can petition them, they could get a green card. I believe a certain group of them, their TPS is extended, so they get a couple more years, but this might likely be the last one, right? So this big deal was a big publicity stunt, but still they give it a little bit more time, and then this might be the end, essentially setting the precedent that all future TPS for other countries might not be extended, for decades.
I want to say I think you're so helpful to your audience.
Oh, thank you, appreciate it.
Can I do a 42B with a CIMT? Or 42B with the CIMT, is it possible to obtain a waiver?
I think it is extremely hard, and I think most, like 95% of immigration attorneys will probably say that as well. So, anytime I'm quite certain about certain thing, I'll say that, and anytime I'm saying I think I'm in the minority or it's a 50-50, I'll also say that. But if you have a crime involving moral turpitude conviction and you want to do a 42B cancellation or removal in immigration court to get your green card during removal proceedings, I think it is extremely hard. Not impossible, right? As a philosophy major, I never want to say things that are impossible. I've seen plenty of impossible things happen. When you get a pardon by the president, you have, certain amazing stories that you're able to tell. You're on the New York Times. The Palisades fire, you went and you saved the different celebrities, and, if you're a hero, well, maybe, right? So I would, if that's your only option, right, then do it. But if you are not in removal proceedings, I would not volunteer yourself to go into removal proceedings to try to do 42B, which some people do, right? Some people is like, I'm tired of waiting. I don't know if I'm ever going to get a green card. I'm so scared. I'd rather just have certainty. So ICE, here I am. Let me apply for cancellation or removal. I voluntarily give myself up for removal proceedings. I mean, this happened, definitely years ago before the crazy detention stuff, right? But people choose to do that. But if you have a CIMT, I would not recommend it.
Can I apply for N400 in 2027? I had... can I apply for N400 in 2027? I had a annulled case in May 2024, still married, had green card in 22, pending 751.
Okay.
So, yeah, citizenship in 2027.
Yeah, if you are still a green card holder and your 751 hasn't been approved yet, and I don't know if you're still married or not, but you could definitely apply for an N400 to expedite your 751 application.
What's your take on online filings for I-140 and 45 or 765? What's your experience on that? Used them recently. Are they better than physical mailings?
Yeah, great question. I'll say historically, almost the entire immigration world hated it. And because the government has tried it multiple times and they failed miserably, right? So we've seen them fail again and again. This latest iteration, however, right, the past couple years, I don't know if it's AI, I don't know if they use a better contractor than before, but it is significantly better. And we have seen it work plenty of times when clients do it themselves, when we do it, barely, and other law offices that do it. So we've heard good things. Our office still hasn't fully embraced it yet for a lot of different other reasons, but we have seen it work. And some of the pros of online filing, faster response, right? You get your receipts faster, you're able to communicate with the officer sometimes more directly, you're able to upload things faster, it saves paper, saves mailing fee. So there's all those that are pros. I've heard of some cons that I personally don't feel it's that big of a deal, but going to the American Immigration Lawyer Conference in San Diego this year, they talked about USCIS using AI to review cases a lot more. And so when you do online filing, they're able to use AI to look at all the metadata stuff. Whereas if you do paper filing, they have to scan everything in, so none of the metadata goes in. But, you could also just resave as PDF and erase the metadata, but maybe most people don't know how to do that or whatnot. So, I mean, I don't think that's that big of a deal, but for some cases, maybe it is a big deal. And then if AI does catch something that you're not supposed to catch, for example, let's just say you created a receipt, right? You created it. It's not a real receipt. It's you committed perjury. You created it on a computer and you upload it, and AI finds out. Well, then you're screwed, right? So, paper filing, where it's still part of our norm, we still do a lot of that, and there hasn't been hiccups with it. And online filing, they don't allow most things cannot be online filed, and so a lot of things we can't online file. And there's a couple other annoying things about the online filing. But yeah, but generally it is significantly better than before. If you're an individual and it's a simple case, I would probably recommend online filing.
Okay. So we'll take one more question, jump to public charge again, finish up that, and then probably take some more questions. So I stayed out of US longer because of a pregnancy. The doctor said, don't travel, it's a high-risk pregnancy. And I was on food stamps when pregnant. They're a green card holder since 2019. Is this going to be a problem for citizenship?
Yes. The officer will challenge that, and you definitely want to prepare your best to try to explain, but there's no harm in applying for N400 based on what you said, because at the worst case scenario, they review it, they deny you, whether for public charge reason or for physical presence reasons, but on the record, it shows that you tried, and the officer will likely also tell you maybe reapply at a certain date. And if you comply with everything, you reapply, the chance of you getting approved the second time you apply for N400 is a lot higher. Now, this is a different story if you have criminal offenses where you trigger inadmissibility or deportability stuff, because then they can cancel your citizenship application and they can cancel your green card, right? But if it's just the physical presence stuff or good moral character or public charge stuff, you're not at risk of losing your green card.
I presume that N600K you filed, that was in the LA office?
Yes.
And was the I-290B accepted in the same office?
Yes. So what happened was, just go back to it real quick. Client filed the 290B, it got denied. Client filed N600, got denied, and couldn't get another appointment, but they're only here for 2 weeks and they were really struggling, right? So we took the 290B motion to reopen for the N600K case. We took it to the office and said, can you please accept it? The officers accepted it. They didn't cash a check. They didn't, need us to pay for it. They reopened a slot for us. And so the client was able to fly in from Hong Kong, bring his 2 kids, go in for the interview, and next day the certificate was printed and they were able to get it. They had a few requests for evidence at the first day, or else it would have been done at the first day, but they needed some original documents. So they were able to get the original documents, get that approved, and second day they were able to get the certificate. So in total, it was like a few weeks. But yeah, that was a fun case.
Have you ever had a difficult case that involved a 485 case?
Plenty. So many 45 cases. 45 is a green card case, right? And so you're basically asking, has there ever been a difficult green card application? And if you look on our YouTube channel, you'll probably see at least 100 different ones, whether it's fraud waivers, whether it's criminal cases, overstay, unauthorized work, weird ways where people got the I-140 approved, but now they're doing adjustment of status in the U.S. So, somebody who got married, got abused, got divorced, got remarried again, like all sorts of family-based, business-based immigration cases and 45 cases. I don't think I've ever done a simple 45 success story, right? Because then it wouldn't be worth it to do a success story on it. So lots of interesting situations that have happened.
How true is it that no longer a U.S. citizen can petition for specific family members?
Nope, that rule hasn't changed. So the way U.S. citizens can petition for people has all stayed the same.
Had an arrest record, minor, 2024, went to apply for citizenship in 2027. what will be enough to establish good moral character?
It's impossible to know what is sufficient, right? So if I just have these three pictures and documents, then I'm enough, right? If I just give enough to charity, it will be good enough. There's no sufficient amount. So just live your best life. Show the officer this is who I am truthfully, and this is everything I've done up to this day. I have, repented. I have been reformed. I am a new person. I was as young. I was mistaken, but look at me now. And let the officers see everything that they're supposed to see, right? Because especially with the new memo that went out, I think August last year on the good moral character for N400, they look at a lot of things now, which is maybe to your benefit, right? So show the different certificates, the education that you've received, right? Show how you've paid off all the bad debts that you have, that you're financially responsible. Show how much taxes you pay. So the different startups that you have. Show that you have employees, that you care for people, that you volunteer, right? So there's no sufficient amount. It's up to the officer, but that's the wisdom of the U.S. system, where it's up to the individual to make that discretion. You are judged by your peer, right? And so you don't know who's going to review your case, whether they're dog lovers or cat lovers, whether they value family or they value work more, right? But do your best to show who you are.
How far will the denaturalization campaign go?
I don't think it is going to stop. It started in the Obama era, that to really build it out, and it's been in the works for like probably over a decade now, and it's finally being launched. I feel like they have done a lot of work to find all the people they want to denaturalize. So that's why they're so confident in saying that they have 200 cases per month that they want to do. So I feel like it's not going anywhere. It's going to keep on going, and it will become a standardized process. Maybe instead of the 200, a couple years from now, maybe they've exhausted their list and it drops down to 20, 25, 30. But I don't know, right? But I definitely think it is here to stay. I definitely think it is something that is going to new evolving area of immigration law. I think it's going to expand to more things. For example, let's say the anchor babies that were born here, 5 years, 10 years, 20 years ago, and let's say they never lived here. Will they become denaturalized at some point? Who knows, right? It's not on the chopping block part, but 10, 20 years later, will the next, presidency and Congress decide that no, that shouldn't be a citizen, and they created rules around that, right? So we'll see.
I won the green card lottery, did the interview in January, but still pending any update.
No update. If you're part of the country ban, that's the difficult part. Hopefully you get approved, and then you're just waiting for the ban to be lifted. If you're not part of the country ban, you should be able to get it soon.
I did VAWA through an abusive son. He doesn't know. Now he wants to do CP. Can I?
I don't do that much VAWA cases, so I don't really know if I can answer that. Yeah.
Oh, on the good moral character question, my question is, can I have an arrest record within the statutory period?
We do not recommend it, obviously, but what we definitely don't recommend is if you're still on parole, right? It should be completely ended. It should be the fines have been already paid and everything is done. Then maybe consider applying. But if it's a CIMT and you can't argue otherwise, we would probably discourage from filing until it's out of the statutory period.
What is the meaning of 212F? They gave me 212F.
I think that's just admin processing.
And what is the meaning of that?
That just means that they're reviewing your case.
Okay. So not something to worry about?
You might get a request for evidence soon.
Are exceptions for people from travel banned countries real through embassy processing?
I definitely believe it's real. We haven't done it, but in the past, whether it's during eras of COVID or other situations, we've done plenty of national interest exceptions. It's real. You could apply for it. There's a consular officer reviewing it. It might not be approved, but they're definitely taking the time to do it.
Okay, 4212F. It was after the interview they gave me. Is this going to be a problem? Oh, and I'm one of the 75 country
Oh,
ban
I
out of
see.
the U.S.
Well, so yeah, the 212F happens only after the interview for everyone. And then if you're part of the country ban list, then that's probably the reason. So they're still reviewing it. They have to wait for the ban to be lifted before they call you back in. So maybe that's a good sign. No, you don't need anything else, and your case will be approved once politics change.
I see. Is it hard to get citizenship after beating 42A?
Yes and no. It's a different requirement. You could beat the 42A, you get your green card through cancellation and removal, but don't speak a word of English, and that's a requirement for N400, right? N400 also looks at other things. Good moral character in the past 5 years. You could win the 42A, but suddenly get like multiple DUIs, and suddenly you don't qualify for naturalization anymore, right? But if you're just comparing the amount of effort and stress and pain to go through 42A compared to N400, it's not comparable, right? Like N400, the application, the interview, that's like playing handball, right, at a court. They just compared to being like, dodgeball with spikes and fire, right? Like 42A is crazy difficult. So if you want that, take that same energy and you put it to N400, you should be able to win it.
Thanks for all your help and support. Regarding an N600, if the applicant was detained and was not able to show for the bio appointment, based on that, the case was denied, can he request to have the case reopened? It's been over 3 years.
They filed for an N600
Yes.
and they got detained
Yes.
and they couldn't show up to biometrics.
Correct.
So the answer is yes, you can always file a 290B to reopen your N600 case. However, you will still get a biometrics appointment. Hopefully you make it this time, and you'll get an interview. And at the interview, they will go back and talk about, well, exactly why were you detained, and adjudicate the case. And if they approve it, you get the green card. If not, they'll deny it again. I mean, not green card, citizenship.
Are people who got their green cards through marriage and then divorced at risk of denaturalization?
Not from anything we've seen. That's not the target of what the denaturalization effort is going after. But if you're saying that it was a fraudulent marriage and they're part of a big ring of people who have done it, and some of the people within that ring are getting denaturalized and arrested by FBI, and are you at risk? Well, then yes, right? And your risk might not even be denaturalized. Your risk might be notice of intent to revoke the green card that you do have, right? So that happens. But if you're saying it was a real marriage, it was a real divorce, and I've lived in the U.S. for 5, 10, 15, 20 years now, and I want to become a citizen, or I became a citizen, will they go back and challenge my case and denaturalize me? I think the percentage of that is like less than 0.00001.
Okay, let's jump into the success story for today.
All right. So, a client's from Switzerland. He designs typeface, graphic designer. He's been doing it for a long time in Switzerland. He now wants to come to the US, start a company, invest in his own company, and be able to work here and live here indefinitely. We did it. It was hard and easy at the same time. It was hard because we know the consulates do not like consulting, designing work, especially in the age of AI. You designed letter A or O better. I mean, my kid it's 5 can do that, and also AI can do that. Why should you do that? And also, you are the designer. We don't want more designers. We want investors. We want you to be able to hire designers. So that's why this case was hard, because it's a consulting, it's a design firm in the age of AI. But what was really strong about this case was that he had some amazing clients, and his story backs it up. His clients include some of the Fortune 500 companies in the US. They all license a lot of the things that he created. So over the past couple of decades, he designed a lot of typeface that is really famous, and he puts it on these platforms, and a lot of big name companies license it and uses it. And he's able to make a pretty nice living. But now he doesn't want to do it anymore in Switzerland. And when we find out more, when we're talking to him about this case, is that the design market in Europe is like 1/10 of the US. Like it's just a few billion, no, not billion. It was only like 20 million or something in Switzerland, around Europe, of people actually paying for these type of services. But in the United States, it's like 10, 20-fold. And so by coming to the US, by designing more, by engaging with more companies, he's able to expand the number of clientele that he has, and he plans on hiring all these workers for sales and for design. And that was a very convincing argument. One, because he has the experience, it aligns with his career, it aligns with the market, it aligns with the need, aligns with his talent, and his business plan includes hiring a lot of employees to be able to do it. That was the hard part about this case, because even though that was good and true, but he cannot be the designer, right? Because if you're the designer in the US as an E2, then you are stealing design jobs from a designer, right? You're supposed to be hiring a designer. Now you are the designer. So you're supposed to be the E2 investor to start the company, hire designers, train them, have a sales, have accounting, have legal, just having all the necessary departments of a company, and then you can keep your E2 visa. The investment amount wasn't a lot. It was just slightly over 100,000, starting a consulting firm with a few like lease agreements. So the expense was low. Didn't have to spend a lot of money because he just needs a computer to design stuff. And he already had all the equipment, right? So he could work from home. He doesn't have a lot of expense. He invested only about 100,000. The thing that was really good was his background, his resume, and he had US customers that were licensing his typeface and his designs. They weren't directly signing necessarily contracts with him, but he had a lot of proof that he has contributed to the United States. It was a difficult case because we were not sure how the consulate would review it, but in everything we prepared, we submitted. The case was immediately approved and got like a 4-year visa to be able to come to the US. So, I mean, I've had some bad experiences with consulting and design in the past. So when we were doing this case, I was like really worried about it. It was Andy's team that worked on it. And I was like, oh, I don't know, but we'll see, right? And again, not a lot of Swiss people do E2s to come to the US. In fact, everybody wants to leave the US and bank in Swiss, and you don't want to have any green card or citizenship in the US if you want to bank in Switzerland, right? And so it's rare for people from Switzerland to want to come to the US, but the market, which is so much better, and the tax is so much lower. And so being able to come here, make a lot of money, and then eventually go back and then bank there, that's the dream. And this client is able to do it. So just want to share this story with you. Again, it's been a while since we did an E2 story, but it's happy. It's a happy ending.
Okay, that is our time.
Thank you guys. See you guys next week. Bye.